The hearing opens with what appears to be a routine agreement, but that impression falls apart almost immediately. The biggest problem is not the parenting schedule. It is the communication failure surrounding the guardian ad litem's updated report.
Okay. Ms. Marshall.
For the record, did anyone?
Sorry.
Excuse me. For the record, did anyone receive my amended plan, parenting plan?
No, I did not, because maybe I misunderstood the announcement. I thought I asked you, were you amenable to the guardian ad litem report following it? And I thought you said yes. So you're indicating
no, I did not. I haven't seen it at all.
The original one you haven't seen?
She just had you just said that she had an amended parenting plan. And that's the one I'm talking about.
Yes, I understand that. But the original one that you got, that's the announcement was made from that one. And the announcement Ms. Fuller made was that you all were amenable to that plan. Was that not your understanding?
Yes, I have several issues with the original.
Okay, so then I misunderstood you, because I was thinking that you said you were all amenable, and so 15 minutes is what I cut out. If you're disagreeing with the plan, that's a full hearing. That's not 15 minutes. So your position is you disagree with the plan?
Yes.
Okay. All right. Well, that's a whole different ballgame. All right. So that means I am, so that I can kind of get an understanding of time. What specifically do you disagree with?
The entire thing.
Ma'am, you don't disagree with the entire thing unless you're saying that you don't want the child to have any contact with Mr. Habib.
I would like to have supervised visitation.
Okay. All right.
I also have other things that I actually filed into the case too with Mr. Habib's arrest records. So I have that filed as well.
Okay. So on that matter, we're going to put this one towards the end because this is a full hearing. So that it's definitely not 15 minutes. It's more like 2 hours at least. So hold. Let me go back and look. We'll go back to. Let's see. So, Ms. Marshall, were you able to send me the first guardian ad litem report?
There was none never filed, Judge.
Okay. So, okay, Ms. Giles, is the updated report, this is the first written report?
No, there's 3. There was one in March of 23, November of 23, and then this one that from yesterday.
Okay, Ms. Marshall said we don't have it.
I can send that quickly right now.
I don't see them in the file or any seal orders.
Okay, maybe we get them via email. Maybe we told her to release it via email.
Yes, they were all emailed into the court, Your Honor.
Okay. All right, can you send those to me, Ms. Giles?
Yes, I can.
Excuse me, Your Honor.
Yes.
For the record, I just received this report and it's a lengthy report. And due to the seriousness of this matter, my child's safety being at stake, I have to consult with legal counsel. So I need to continue.
No, we're not doing that. Your child's safety has always been the issue. That's always been the issue. So you should have had legal counsel from day one. This report is I understand that it might be new to you, but this report has information in here that generally is already well known to you. The only thing this report does is setting out the information that you provided to her for one and making her recommendation. So we're not starting this over. We're not taking a 22 case and you starting to get general counsel right now. That's not happening. Okay, we're going to go through it. I'll consider the evidence that you have presented. Because quite frankly, I did look through the evidence that you presented to the court, and I do have some concerns as well. But we're not starting. This is not starting over. Okay.
I just sent those to Miss Marshall.
Okay, give me a moment. So I was trying to figure out what happened to the guardian ad litem reports because we didn't receive them. We did receive them, but they went to the division 11 and 12, which basically are our backup divisions that we use to help with the COVID backlog. So they went to their staff because they were helping us with those cases. So I never got an opportunity to digest.
The judge's reaction to the summer schedule exposes a broader judicial philosophy. Rather than accepting a complicated compromise simply because both sides discussed it, the court immediately searches for a cleaner framework that leaves fewer opportunities for future disputes.
What was essentially going on, particularly in this case. I do remember somewhat remember the first time I met with or dealt with this particular file. Hold on, make sure. And I think the other times thereafter have been with another judge, which is kind of unfortunate. So usually there are cases that I kind of know Miss Marshall knows not to put with anybody else because they have some particular things in there, and I try to be mindful of sending those that I have a lot of history with or ones that got some really concerning issues. But this one did not stay with me, but based on the allegations in there, it should have. And so I'm just getting the opportunity to digest this. And so although generally I would not want to give a continuance on this, I might have to. And let me tell you why. So far, this is what I've seen. Ms. Bouvier submitted some records regarding Mr. Habib. They are very alarming to me. Not the molestation issues. I think that's been worked out. But Mr. Habib has some history of drug use that involved, looks like some sort of home invasion. Then there was some type of police chase issue. There's some issues of marijuana being grown in the backyard. Those are some issues that are very alarming to me. And I need to look at all of these records because I can understand why she might have some concerns, because quite frankly, without a picture or a landscape I'm sure Ms. Fuller is going to give me, this doesn't look good. And I would be very concerned about a child going into that environment. I'm sure there are some things that we need to be mindful of, and I know it has some history behind it because I know that those things happened a few years ago. But they happened, or at least that's the allegation. And so I need to look at it. The reports are just too much for me to digest at 3 o'clock. So, because I think she submitted, I went back through and I looked at the exhibits that she submitted, and then I went back through Ms. Giles' reports that also have additional criminal issues on there. I think there was even one for Ms. Bouvier dealing with cruelty to children.
That's correct, Judge.
That I need to take a look at as well. So unfortunately, although generally I like to kind of push forward, I do think I need a moment to digest all of that.
May I ask, Judge, these allegations did happen during the time that Mr. Habib and Ms. Bouvier were together in their relationship. She had some criminal charges as well. She, subsequent to those allegations, those charges, they were still co-parenting. Mr. Habib had the child for some time, and they were still co-parenting. The only reason why Miss Bouvier said that she doesn't want him to have contact with the child is because of this child molestation allegations, which were
that's not what she put in her reports. Her put in her reports were the safety of father dealing with those allegations. That she didn't just say molestation. She said also the general safety of the child. So here's the thing. I really don't care to some extent if Ms. Bouvier was like, okay, I'm okay with him staying with her. I may not be. Because, if you got somebody breaking down your door to come into your house and then the police alleging that dope is everywhere, that's alarming to me. Okay.
And that's when they were living together, Judge.
That might be, I don't know. Like I
But they're-
said, I can't, it's no need of you explaining because I understand there is a landscape to it. I'm just telling you, I don't know what that landscape is, and I need to give you the opportunity to give that to me.
The request for another continuance receives almost no traction because the judge views timing through the history of the case rather than the latest filing. The court makes it clear that child safety has always been central, meaning new legal representation cannot erase years of litigation.
So what I need to do is read through Ms. Giles' reports so that I will have a better understanding of where we all are instead of jumping to conclusions. I don't want to do that. So, and then stuff all the information in my head and then listen to you guys. I don't think that would be fair. So what I'm asking is, what I'm suggesting to do is let me read through her reports. And then you can come give me the landscape, like they were together, she was okay with it, you know, that kind of thing. I like I said, I'm assuming there's a landscape to it,
Right.
obviously. But I don't know what that is right now. I'm just looking at it from, and it, you know, has some shock value right now. So let's just have cooler heads, give me an opportunity to review it, come back, and then we'll have a hearing on it so that I can see everything more plentiful than kind of the shock of just kind of pulling it all together and going, okay, why this? Where is this? Where does this fit? You know, it'll be easier for you all, for me to be able to digest the information if I reviewed it prior to. And like I said, a lot of these cases, when I have cases like this, I like to keep them. I don't like to kind of give them out because it's hard for me to pull the information if another judge hears them. So Ms. Marshall normally will tell me, Judge, you can't pull this one on that calendar. Don't put that one on the calendar. For some reason, this one didn't happen that way. I'm not certain why, because it just, I don't know. But this is one that requires a little bit more information for me. I'm not blaming Ms. Marshall for that. I'm just saying that this is, you know, one of those things. Sometimes we don't know, you know, how much information and what sort of the allegations are. I do remember that initially the allegations appeared to be dealing with child molestation. And then I was concerned about Miss Bouvier's mental health. So I think that was where my focus was, on that issue. Now I'm reviewing the reports, and there's reports about the overall safety of this child dealing with drugs and home invasions and cruelty to children. It's just a lot of information, and I need to pull it all together. So we're going to cancel the hearing, or we're going to reset this hearing. I'm going to go through the reports that Ms. Giles presented, and then I'll be better prepared when we reset for the next.
I have one last beg, Judge. One last beg. So part of our issue is, I think we have not been able to work out some sort of amicable agreement with Miss Bouvier. I feel like if we reset this another time, and there's a long period of time where she wouldn't get the psychological evaluation done, etc. So we weren't able to do any kind of visitations during Christmas, etc. Mr. Bouvier, he moved in with his mom. She's a licensed attorney in the state of Georgia. I would ask the court at this point, just as an interim order, that he can have supervised visits at the grandmother's house pending this matter.
Defense counsel attempts to reduce the impact of the allegations by emphasizing chronology and continued co-parenting after those events occurred. Strategically, that argument suggests the concerns may not have been viewed as immediate dangers at the time.
Grandma, he has a significant relative connection. They do have that criminal history in the back. But as far as grandma, if she's able to supervise Malaya visiting with her and dad while he's at her house, I would just ask that as a concession so that he can start to rebuild his relationship with her.
All right. And Ms. Giles, what's your position on that?
I don't have any issue with that, Your Honor. I do think the relationship with Malaya needs to start sooner rather than later. I don't have any issues whatsoever with Miss Francis, who is Romario's mom. She's, as Miss Fuller said, she is a member of the bar. She's always been very forthcoming with information. I believe she's extremely responsible, and he is living with her as confirmed by her.
Okay, Ms. Bouvier. You need to unmute.
Okay. As long as the grandmother is there, I'll grant that.
Okay, so we'll start that. We'll do that on the weekends. You wanted to start this weekend, which
This
weekend is this, the third?
This is the third weekend.
Third weekend.
So we'll do first and third, and then we'll put this back on the calendar next month anyway.
Okay, that's fair, Judge. Thank you so much.
Understood.
Thank you, Your Honor.
And Miss Marsh, can you forward that to Dion and tell Dion to print all of those reports down for me, please?
Yes, ma'am.
All right, thank you. All right, y'all take care.
Thank you.
Thank you, Judge.
All right.
Thank you.
The decision to postpone the full hearing is less about delay and more about judicial preparation. The judge repeatedly explains that complex custody disputes require continuity, institutional memory, and familiarity with the evolving record. Cases involving overlapping allegations, psychological evaluations, criminal histories, and child welfare concerns become harder when multiple judges rotate through them. The court openly recognizes that fragmented handling can produce fragmented understanding. Even while continuing the hearing, the judge remains focused on preserving the child's relationship with both parents whenever safely possible. Father's attorney capitalizes on that opening by requesting supervised visits instead of unrestricted parenting time. That proposal reflects strategic realism. Rather than demanding everything immediately, counsel asks for a limited arrangement that addresses safety concerns while preventing further erosion of the parent-child bond. The hearing ends with one of the most revealing moments of judicial balance. The guardian ad litem immediately supports supervised visitation through the paternal grandmother, not because every concern has disappeared, but because the proposed supervisor already carries credibility with everyone involved. Even the opposing parent ultimately accepts the arrangement once that safeguard is confirmed. The judge's temporary ruling reflects a broader custody principle, preserving family relationships whenever protective conditions can reasonably reduce risk. Instead of choosing between unrestricted access and complete denial, the court creates a middle ground that keeps the child connected while larger factual disputes remain unresolved. That temporary order also signals something important for the next hearing. The final custody outcome will depend far less on accusations alone and far more on which evidence ultimately survives careful judicial review.